You're listening to Africa Business Radio, where you get up-to-date insights on the Africa business landscape. Log on to www.africabusinessradio.com. Your favorite shows are available on podcasts. Download them on our website and mobile app. Africa Business Radio, towards a profitable Africa.
They are 1.8 billion globally. They would make 75% of workforce by 2025. They will outspace earnings of baby boomers in less than 10 years. Smartphones and tablets are the argument settlers and fact checkers for every conversation. Get more insight on African millennials on Africa Business Radio, towards a profitable Africa.
That's cool on the beat.
I mean, I'm really enjoying the conversation on labor law. I had to play back, the podcast version of our conversation last week Friday, and I have Mayowa Arokodare, back in the studio again to continue this very interesting topic on labor law. But before then, it's Tomi Wale on the African Millennial Radio Show on Africa Business Radio, and I'm enjoying the Wednesday. I'm enjoying the week. It's the third day of the week. I hope monies have come in yesterday. I hope the meetings are going well. I hope the break time is looking really good. And from the conversation we had last week, I hope you guys are beginning to take some measures in your office. Please don't cause war. Do it with a bit of diligence, and let's get life going. All right. So a brief introduction about Mayowa Arokodare for those of us who haven't listened. I think it's important for you to listen to the last episode to, get in the mood and the flow of what we're going to be talking about today. But, Mayowa Arokodare is a Senior Counsel and Finance corporate and commercial team lead at a leading Nigerian law firm. Over the past 13 years, he has gathered multidimensional experience across key sectors of the Nigerian economy and has advised several local, international, cross-border clients on compliance aspects of Nigerian industrial relations and employment law. He has been described as a highly effective attorney who is able to work closely with relevant stakeholders, including board members of clients, C-level executives, regulatory agencies, and government officials. Mayowa is an associate of the Chartered Institute of Taxation of Nigeria. He is also a Securities and Exchange Commission-accredited capital markets consultant, authorized to discharge the functions of a compliance officer. Mayowa, how are you doing?
Very well, thank you. Hi, everybody.
Everyone, I believe is fine. I'm sure my folks in Mali and Senegal and South Africa, and some parts of UK and Northern America are actually glued to this now to listen to, let's say the next thing happening. So just jump right into this, right? I understand that some people want to work overtime during their probation phase, right? And just trying to prove, themselves right and everything. And I understand that some employers actually get to abuse, those periods. What do you think an employee should know about that to defend or just to protect themselves from abuse in this period?
Well, thank you, Tommy. I'm just going to keep this simple, right? Because I don't want to, like you said, I don't want to stir up anything. But it's important for employees to know that while the expectation is that during the probation period, they will strive to meet the expectation of the employer, it's also important for them to know that they ought not to be subjected to exploitation or other forms of unfair labor practice. Recall that I said sometime last week that by Section 7 of the Labour Act, certain terms of the employment have to be reduced in writing. One of such terms that have to be in written form in the contract of employment is the hours of work. It has to be stipulated 9 to 5, 8 to 5, 9 to 5, 8 to whatever, Sometime in 2019, there was an amendment to the National Minimum Wage Act Laws of the Federation 2004. There was an amendment in 2019. Based on that 2019 National Minimum Wage Act, I will recommend, and this goes for the employer and the employee, I will recommend the inclusion in the contract of employment terms that guarantee overtime pay, where the employee is required to exceed his normal hours of work. I don't want to get into the complexities, but I'm just going to say that the contract of employment, the employee should push, right? I know this is tough because it's the employer's market actually, right? But as much as you can, push for the contract to stipulate your work hours and then to also make provision that guarantee overtime pay once you exceed the normal work hours. Why is this helpful? It is helpful for two reasons. It will then prevent the employer from accumulating enormous overtime charges and prevent abuse. You don't have indiscriminate demands for overtime pay. So it also works in favor of the employer, right? To put it there, right? So we put in place measures to make sure that nobody's abusing the system. So secondly, it will also ensure, it will also serve to ensure that the employer can track productivity during the extra time spent, and what have you. So let me just say, lastly, I wasn't going to go into this, but the summary of that National Minimum Wage Act 2019 is that it has now redefined the meaning of a part-time worker. Prior to 2019, the position of the law was that a part-time worker is anybody that works less than 40 hours 40 hours a week. That's a part-time worker. But by virtue of the National Minimum Wage Act 2019, a part-time worker is now anybody that works lesser hours relative to the average worker in that industry.
Okay.
Do you understand? Such that you will be entitled to overtime pay where you exceed your normal working hours and you exceed what is average in the industry. By virtue, a lot of people don't know that, right? But that's the position of the law. So summary, the National Minimum Wage Act 2019 has now redefined who a part-time worker. So you may now be working 60 hours a week, yet you are not hitting what is average in your industry. But anytime you hit the average and you exceed it, by 2019 amendment to the national, you are actually entitled. But the truth is, if you don't know that you have a right, you will not be able to, pursue it and, seek remedies when those rights are trampled upon. So you push for it, right? That, look, let this contract stipulate my work hours. Let it also entitle me to overtime pay once I exceed it.
Well, that's really, really enlightening right now, because so it's not wow. So I'm not going to talk about it. That's a part-time worker. That's a part full daytime worker sometimes, because you'll be working, man. Now, I'm very, very concerned about security.
Right.
If I don't think that the time you're leaving or the time you're going back is not secure, I mean, just come sleep in my house and then go the next day. Right. I'm very, very concerned. I've been on the road, at some point, earlier in my career, and they were not safe. You know what I'm saying? Now, what are the things employers must do to ensure? I understand that, HR will say maybe welfare, providing staff buses and everything. But from the law standpoint, especially from employment law, what does the law say about, making sure that your employees are safe, especially in commuting to and fro?
Well, I mean, of course, it's right that human capital represents the most valuable asset of any organization. So it means that it is incumbent on any employer to ensure the safety of its employees. As a matter of fact, this is not just even common sense. It goes beyond the realm of common sense. It is law. The Supreme Court has said in one of its cases, specifically Yere and Bendel Feed and Flour Mill Limited, it was decided in 2008. But the position of the law is now that employees are generally under a duty to take reasonable care for the safety of their employees, and not in all circumstances, and not to expose them to unnecessary risk. The operative word is unnecessary risk. There are certain risks that come with the work, but if the risk is not associated with the work, then you should not expose.
So, for example, female workers living in the dark, is unnecessary risk.
That's an unnecessary. That's unnecessary because the truth of the matter is, those are not typical work hours. Do you understand? So why am I made to leave after work hours, so that may be exposing. And you see, the truth of the law is, the beauty of the law is the ability to argue either side, depending on who you are representing, but everything at the end of the day will turn on the peculiar facts and circumstances of each case. Okay. But as a general rule, the position of the law as laid down by the Supreme Court is that you have a duty to ensure the safety of your employees in all the circumstances and not to expose them to unnecessary risk. Now, having said that, it is now important for organizations to devise policies that will enhance personal security, as well as the security of property, as well as that of the organization as well. Now, why? How do you go about this? You go about this by undertaking a thorough staff risk assessment exercise. So risks so each employee will have unique risks. The risk that pertain to you will be different from those that pertain to me. Our offices might be situated in VI, maybe Ohinjola Yemi, and you stay on Adetokunbo Ademola, whereas I live at Yanopaja. So we have different risks. The point is that in addition to undertaking that staff risk assessment, you want to then take actions that will minimize the identified risks. Exactly. Now, such actions will include introducing monitoring technology where the employee consents. This will guide against, this may be helpful in the cases of kidnap. Do you understand? Yeah. Where the employee consents to it, because this may then raise issues relating to privacy, right? So issues relating to monitoring technology, allowing employees living in hotspots, unsafe areas to leave work early, providing employees safe means of commuting to work, organizing trainings on personal safety. So it goes beyond all these things. You could actually organize trainings for them, for ladies, how to protect themselves, defend themselves, harm them with pepper spray and other things, and all that. It just shows that the employer is thoughtful, is looking out for the employees, has their best interests at heart, is bringing up solutions that are customized to each employee and all that. So
I mean that's very good, because as you were saying some things earlier, I actually thought about, so you're working in Victoria Island, for example, and you live in Ipaja, and then everybody has to leave work at 5. Someone who lives at Yaba is home, before someone who lives at Ipaja, and then the person can be a lady. So I like what you said, and that monitoring part, just hope other people can consent to it, because so anytime someone actually comes to my place and is living, male or female, I tell you, no, please, can you send me your live location via WhatsApp? Right. I want to know when unless maybe you're now going somewhere else. This is where you're going, right? Okay, just send me your live location, so I can just keep checking. If it's you're taking Uber or Bolt or something, I just say, you know what, just share your ETA with me, so I can just track, because it's very, 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 very important. So I understand that certain documents are required from employees, most importantly, adding personal data to companies in the intranet. Are there protections for employees in this regard, so that I resign at some point and I leave at some point? What makes my data with that company safe? Even while working there, what makes my data safe?
Okay, good point, good question. There's the Nigerian law affords protection to employees in that regard. The current law on the subject is the Nigerian Data Protection Regulation 2019, which makes extensive provision relating to the protection of personal data. Now, for example, employers who are involved in the collection, storage, and processing of personal data. Now, the point is preliminary point. So you may be asking, what is personal data, right? Personal data relates to any information. Personal data refers to any information that relates to an identifiable person. So it will include things such as your physical address, photographs, email addresses, bank account details of next of kin, post on social network websites, as defined by the law, right? This is not me, right? Post on social media networks, medical information, unique identifiers such as MAC addresses, IP addresses, IMEI numbers, your SIM registration details, and what have you. So the regulation, the Nigerian Data Protection Regulation 2009, applies to all categories of personal, data across both the public sector and the private sector. So back to the point I was making, right? The point is that there's an obligation on employers. Any employer that is involved in collection, storage, and processing of your personal data has an obligation to develop and maintain security measures that are necessary to minimize the risks of your personal data getting into the wrong hands.
Absolutely.
Furthermore, some of the obligations imposed on the employer under the regulations include obtaining consent, employee consent, prior to processing their personal data. Okay. I may give you consent to collect. I may not give you consent to process. Do you understand?
Okay.
So you must then.
How do you mean process?
So if I give you my personal information, maybe for the purpose of you knowing where I live.
Okay.
You have collected the information.
And processing.
But there may be processing. You may need to share it with some other third party. You may need to share it with banks. You may need to share it with other people.
Okay.
You need my consent. So you need the consent of the employee, right, prior to processing their personal data. The consent must be in writing and must be without fraud, coercion, and undue influence. If an employee says he's not comfortable sharing his medical record, it is what it is. Don't deceive them into getting that information, or you have the law to contend with. You also have an obligation to inform employees of the specific purpose for which you are collecting the personal data. You don't just send information out or you just send a firmware email and say, before the close of business, provide the following. You need to explain to employees why is this information being requested, or is being requested in connection with pension remittance, is being requested in connection with life insurance that is required under the Pension Reform Act. A lot of people don't know that the law is that every employer has to insure your life up to 3 times more than your 3 times the value of your annual remuneration. So say you earn 20 million a year. The law is that they must do that. So if anything happens, God forbid, your next of kin or the administrators of your estate are entitled to 60 million straight up. Apart from any other thing, it is the position of the law, but a lot of people don't know it. But the point is that they need to let you know why they're asking for that information. Something else that the law requires is that they must ensure that the personal data of the employee is adequate, accurate, and without prejudice to the dignity of the human person. So certain information it is unnecessary for you to ask for certain information. Or even if you were going to ask for it, you must ask for it in such a way that will not degrade the person. So for instance, we have laws relating to HIV, AIDS, Anti-Discrimination Act. Even if you were going to ask for that information, you should be sensitive and whatever. And lastly, you must ensure that personal data, and this is to your question, you must ensure that personal data of employees are stored only for the duration for which it is necessary. So there's no need holding on to my personal information any longer than it is required. If you require it for pension remittance, the moment I leave your organization, certain information, you need not hold on to them anymore, because the longer you hold on to them, the more the risk of them getting into the wrong hands and what have you. So you hold on to them only for the period for which it is necessary.
I mean, this is really good. I think with every part of this thing, it's always just so enlightening. Lightning is the thunder.
Enlightening.
Yeah. I'm sorry, lighting is light.
Yes.
Electricity. Lightning is the thunder. So enlightening. Is it the electricity one or the thunder one?
And so English is not like maths. It doesn't make sense all the time.
Okay.
Like laughter, daughter.
Yeah, exactly.
Right.
All right, guys. Let's go on a short break, and then we'll be back to a couple more things. And yep, I'm really enjoying this. I don't know about you. We'll have a short break, and we'll be back in a bit.
You're listening to Africa Business Radio, where you get up-to-date insights on the Africa business landscape. Log on to www.africabusinessradio.com. Your favorite shows are available on podcasts. Download them on our website and mobile app. Africa Business Radio, towards a profitable Africa.
They are 1.8 billion globally. They would make 75% of workforce by 2025. They will outspace earnings of baby boomers in less than 10 years. Smartphones and tablets are the argument settlers and fact checkers for every conversation. Get more insight on African millennials on Africa Business Radio, towards a profitable Africa.
That's cool on the beat.
All right, guys, welcome. I'm sure we are really digging into this. And yes, if there's anybody who is far away, call them back, to where the speaker is, and let's continue, this wonderful conversation with Mayowa Arokodare. Now, Mayowa, I'm not sure if there are many cases of racial discrimination here, except where employees are, probably Westerners or Asians, and we've had cases of how they, go about the discrimination with, people of color, right? Or let me just say Africans, and then of course we have cases of gender discrimination, things like that. What is the stand of the law on this? Because I find it very, very disgusting.
Well, the truth of the matter is that the law is clear. Putting it simply, the position of the law is that equal treatment for equal treatment and equal opportunity for all employees, irrespective of gender, race, religion, or nationality. That's the position of the law. There's the International Labour Organization. There's the Convention C111, which is the Discrimination (Employment and Occupation Convention) 1958, that was ratified by Nigeria in October 2002. It prohibits discrimination in all its ramifications. Now, having said that, right, the National Industrial Court is the National Industrial Court of Nigeria is the court that has exclusive original jurisdiction relating to on matters relating to labor and employment law. Now, Order 14, sorry to get technical, Order 14, Rule 2 and 3 of the National Industrial Court Civil Procedure Rules 2007 sets out the procedure for making claims in respect of discrimination. The law is that where in any action before the court, the claimant is the person who comes to the court to say, hey, I've been, unfairly treated. So where in any action before the court, a claimant alleges workplace discrimination, that claimant must state whether the alleged workplace discrimination is on the basis of the following grounds: ancestry, religion, gender, union affiliation, tribe, handicap or disability, health, pregnancy, on any other ground. So the position, you see that it's very expansive. So it goes beyond nationality, it goes beyond gender, it goes beyond age. So some people even discriminate on the basis of age. That's one. You recall I told you last week about job applications, about saying, if you are older than 27, you can't apply. That's discrimination, right? So beyond that, the claimant should also, in his complaint, indicate the activity, right, including the mode, the manner, the correspondence and communication, basically evidence that constitutes the alleged workplace discrimination. So putting it in summary, the law prohibits discrimination in whatever form, and then the procedure for initiating a claim in respect of workplace discrimination is very clear. Basically, all you need to do is state on what grounds you've been discriminated against, then provide evidence, whether in form of relating to the mode, the manner, the correspondence and communication, and then you have your day in court.
Okay. I hope people can actually take this fight up, because it was FCCPC, Mr. Tunde Rukera, that actually went to lock up a Chinese restaurant at some point. I don't know, I loved it. Some people were saying that no, it's right. You can't. That sounds very, very discriminatory to me. You can't say that people of color can't come to your place. I don't understand that. I don't. Okay, so now there was a rising case, last year of harassment, on the internet, and most popular of them was sexual assault, or sexual harassment. What other forms of harassment, could come up and how can employees actually be protected from this?
As a matter of fact, harassment may manifest in forms other than that which is sexual in nature. Sexual. So there's actually an entire. There's about I could come up with about 200 pages on the point. And that's why we call it sexual and other forms of workplace harassment. So the point is that sexual harassment is just one aspect of harassment. Now, such other forms of harassment may include discrimination. Is a form of harassment. Okay, do you understand? I say there's an office party, Yoruba people are not invited. That is some form of harassment. You could also have physical harassment in the form of workplace violence. That's harassment. I know of employers who slap their employees. There's a particular employer in the construction sector, in the real estate sector, that is known for hitting his employees, slapping them and smacking them. Yes. He's a popular employer in that sector. Physical harassment in the form of workplace violence. You could also have power harassment.
Adults.
Oh yes, absolutely. I can even mention it off air. You also have power harassment, where and that one is basically that's workplace bullying. Where someone in the position of greater power uses that power to harass or to bully. You could also have psychological harassment, and this one goes on more often than people would even take note of. You have psychological harassment in the form of general hostile behavior that targets a particular person. It could manifest in the form of exclusionary tactics, like withholding relevant information. People are meant to submit this information by close of business. You exclude that person, you don't inform the person, so exclusionary tactics, withholding relevant information, or even refusal to assign tasks. So you have a team of 12 people, you assign tasks to 11, and you continuously exclude this person as a form of psychological harassment. The point is, employers need to devise policies that regulate harassment holistically, sexual and other forms of workplace harassment, bullying and what have you. They need to devise policies that regulate harassment with adequate, not just paying lip service, with adequate grievance remedial mechanisms in place to enforce those policies. The truth of the matter is that sometimes employers are caught between a rock and a hard place. If an employee comes up with an allegation of harassment against another employee, now the employer, if he finds in favor of the employer, of the person complaining, the person, okay, so I take cognizance of the fact that we're constrained for time, so I'm just going to wrap this up. Relevance is the case of Ejike Maduka and Microsoft Nigeria Limited, that I mentioned sometime last week. So I'm just going to keep it moving at this point. It's all right.
Okay, sorry, can you maybe just bring back that case again?
Okay, so Ejike Maduka and Microsoft Nigeria Limited and 3 others. That was a matter that was decided by the National Industrial Court a couple of years ago. In that case, Mrs. Ejike Maduka, married obviously, brought an action against Microsoft Nigeria. Microsoft Nigeria, the country manager and CEO of the company, and 2 other persons. But the point is that in that case, the National Industrial Court found that the allegations that the third defendant, that is the country manager and CEO of the first defendant, consistently tickled and touched the claimant and some other female workers in the office against their will and despite their protests. The court found that allegation was proved by the evidence that was tabled before it. The point I was going to make was that an employer can actually be vicariously liable for the conduct of his employees that perpetrate harassment. So it is not so, and that's the point I was making, that it is not sufficient for you to say, we have policies, don't do this, don't harass people. But you must also have grievance remedial processes, that if you do this, this is the sanction. Because if you are seen to tolerate, condone, or even promote harassment, then in addition to the perpetrator being held liable, you will be held liable, because you'll be liable for the conduct of your employee.
Wow. Okay. So don't what's that thing now? Don't encourage it.
Well, don't encourage, don't condone.
Call it out. Don't condone.
Don't
cut the, what's that thing that causes cancer?
Oh yes,
cut it out. The tumor. Yeah, cut it out immediately. Call it out, and just get it going. And I'm sure there are people who are in certain environments that could be tough, especially where employers just walk into the office and just sack people. I've heard stories of that. I mean, okay, you know what? I think what I'm going to do is I'm going to ask you that question on Twitter, right? And then I'm going to ask Arokodare NG that question on Twitter, and then Arokodare NG now responds to that. So guys, we're going to ask the question this evening via Tomiwale_ on Twitter, and then check out what Arokodare NG has to say about that later on. All right, guys. Mayowa, thank you so much. This was like a masterclass or something.
Thank you
on labor law, man. I'm always happy about the guests I bring. I try not to expect so much, so that I just take it in full. So when I'm not expecting so much, it means that I'm just opening myself up. Or let's say expect a lot, I just open myself up, really. And then I keep getting filled up, and I'm sure you guys over there also are getting filled up. All right, guys, don't forget to have a wonderful Wednesday afternoon. Go after this edition. The podcast version is available already, so you can share with your friends and family on Apple Podcast, Google Podcast, and Spotify Podcast. You can also check it out also on africabusinessradio.com. All right, guys, I have to be out of here right now. Thank you, Mickey Jagger, my producer, for always being there, telling me when to go in and when to stop. He's raising his hands right now. Dude, wrap up your talk. All right, guys, have a wonderful Wednesday evening. Please stay safe. Right. Bye for now.
They are 1.8 billion globally. They would make 75% of workforce by 2025. They will outspace earnings of baby boomers in less than 10 years. Smartphones and tablets are the argument settlers and fact checkers for every conversation. Get more insights on African millennials on Africa Business Radio, towards a profitable Africa.
You're listening to Africa Business Radio, where you get up-to-date insights on the Africa business landscape. Log on to www.africabusinessradio.com. Your favorite shows are available on podcasts. Download them on our website and mobile app. Africa Business Radio, towards a profitable Africa.